Yeah, the critical issues for risk managers in the energy sector these days involve a lot of recent case law on indemnification and additional insured. So to back into that, from the perspective of the risk manager, their company's making contracts upstream and downstream. And in those contracts, there is always a section that deals with the risk transfer aspects of the contract. And the risk transfer typically takes on at least two ways. We can talk about others as well, but the two important ways are contractual indemnification, where typically the downstream party is promising to indemnify any loss or damage that arises out of the work that they're doing. In addition, they promise to put the upstream party on their insurance policies as an additional insured. The confusion that's come up, and there's been a lot of case law about it, is the definition that comes out of what the scope of the indemnity is and what the scope of the additional insured coverage is. Oftentimes, the risk managers are actually trying to narrow the scope in the same way so that they end up indemnifying the same thing they're giving additional insured coverage for, but it's not being done properly in the contracts. And when the courts look at it, they have to determine where the coverage is going to come from. And so what isn't always recognized, that the court has certain rules that they follow. When they're looking at the interpretation of a contract, they don't look at sources outside of the contract. So when they're looking at the indemnification, they look only at the contract that's in front of them, unless there's some reason why it's ambiguous or there's some reason to bring in other evidence. But that is going to be the basis of their decision. More importantly, the same is true when it comes to the insurance policy. Even though you're trying to define the rights of your insurance coverage through your contract, the judge is going to look at the insurance policy itself and determine the scope of the coverage there, unless the policy specifically ties in or incorporates the contract by reference. So this can't be done in isolation, and the mistake is to either not focus fully on all things that need to be in the contract and also look at the insurance policy independently. So my tip to risk managers would be that you need to look at each of them separately and make sure that they coordinate with each other, and you've thought through exactly what type of indemnification you're trying to give and what type of coverage you're trying to give. The cases are out there, including the case that's probably most famous at this point, the Fifth Circuit decision on the BP oil case, ended up having the same constraint and coming out with a result initially that might have surprised most people, ultimately being reversed and giving probably the interpretation that most people wanted, with a lot of litigation. The idea from a risk management point of view is you don't want the judge to decide. It should be so clear that nobody questions it and goes to court and it ends up without any litigation whatsoever.